Madam Deputy Registrar, can you please call the matter?
Thank you, President Saunders. Caribbean Court of Justice, Appellate Jurisdiction, an appeal from the Court of Appeal of Guyana, hearing of consolidated appeals in GYCR number 3 of 2021 and GYCR number 4 of 2021 between Jarvis Small and the Director of Public Prosecutions and Bibi Shareema Gopaul and the Director of Public Prosecutions. The members of this morning's panel are Mr. Justice Saunders, President and Presiding Judge.
Good morning, Counsel.
Mr. Justice Witt.
Good morning, Counsel.
Madam Justice Rajnatli.
Good morning, Counsel.
Mr. Justice Baru.
Good morning.
And Mr. Justice Jamadar.
Good morning, everyone.
May we have the appearances, please? Thank you.
May it please your honors, Nigel Hughes with Ronald Daniels and Narissa Leander for the appellant Jarvis Small.
Good morning,
Yes.
Your Honors. Arudranath Gosai. I respectfully appear for the appellant Bibi Shareema Gopaul.
Good morning, Your Honors. May it please Your Honors, Tishani Lake appears with Mr. Shalimar Aliak SC for the respondent.
Yes, good morning again, Counsel. Mr. Hughes, are you ready to begin?
May it please your honor, I am.
Yes, please proceed.
Thank you very much, your honor. Your honors, may I commence by saying that I rely on the written submissions that have been laid over with the court. And with your permission, there perhaps just 2 or 3 points I would wish to expand briefly on. And with your permission again, on the ground of sentence, Mr. Daniels will address the court. But I would like, with your permission, to commence with dealing with the grounds 1, 2, and 3 as set out in the written submissions on behalf of the appellant Jarvis Small. On the question, your honors, of the issue of separate trials, the application which was made at the commencement of the trial before the learned trial judge, we would respectfully invite your honors to consider the test that is applicable and the fact that I believe that the test as considered by the learned trial judge and the manner in which it was considered on review by the Court of Appeal was deeply flawed. I invite your honors to consider the test set out in the Queen against Pham, where the question was whether there was a real risk of a positive injustice being caused as a result of the joint trial. And the test was whether the likelihood of positive injustice was real and not inconsequential, and whether when you weighed the prejudicial material against the irrelevant material, it was likely to turn a potential acquittal into a conviction. Your honors, there's no doubt that the testimony of Mr. Nobrega was strong, powerful, and implicated the second name accused in no uncertain terms. It's also evident that the testimony of Mr. Nobrega could not have been used against the number 1 accused. However, the prejudice that was caused as a result, or the likely prejudice at the start of the case that would have been inflicted upon the number 1 accused was significant and could not have been rectified by the appropriate directions of the court. And I will come to the fact that even though the court acknowledged the fact that it can give directions in that regard, the court regrettably failed in any manner whatsoever to give the appropriate warnings to protect against the prejudicial evidence, which of course was admitted against the number 2 accused. In this case, Your Honor, at the end of the day, on the statements that were presented to the learned trial judge at the commencement of the case, all they amounted to, even if all the evidence of previous accusations against the number 1 accused, even if those were admitted and tendered into evidence, it amounted to nothing more than suspicion. The case on the evidence before the commencement of the case, on the statements was weak against the number one. All they had were the following facts, as I've set out in the written submissions, Your Honor. It was the presence of the allegation of sexual misconduct before, which we think ought not to have been admitted, but assuming it was admitted, there would have been that. There would have been the statement of the appellant that he did not kill the deceased, but was aware of who had done it. There was the fact that he was the owner of the dumbbells, the fact that the dumbbells were found attached to the suitcase in which the body of the deceased was found, and that the day after the deceased was reported missing by the number two accused, he was found in a hotel with the number two accused. That was the sum total of the prosecution's evidence against the number one accused. At the commencement of the trial, there was nothing more than that, and if we take that at its highest, that properly located within all the evidence that the prosecution wanted to invite the jury to consider, could not have yielded a conviction of or a verdict of guilty. However, when the testimony of the witness, Mr. Nobriga, whose testimony could not have been used in any way against the number one accused, was taken into account, the prejudice was severe for several reasons. One, the testimony of Mr. Nobriga merely spoke to what the number two is alleged to have said to her while they were both being detained at a police station. That testimony went into great detail about the manner in which the deceased met her horrid death, the amount of force that was used, and clearly implicated the number one accused in no uncertain terms in participating in the death of the deceased. There was no way in which the accuracy of that could have been challenged by way of cross-examination because, of course, Mr. Nobriga was not a witness. She was merely relating what was told to her about the number two accused. So the prejudice created by the testimony of Mr. Nobriga in relation to how the deceased would have met her death, how gruesome it was, and all these facts were not being tendered for the truth of the content at all at any stage, and certainly they implicated the number one. And this was by a witness whose evidence could not have been used against the number one. That would have created, in my respectful submission, Your Honor, severe prejudice against the number one. One, he couldn't challenge Ms. de Nobriga in relation to whether or not she gave the statement. And two, even if the trial judge was to give the appropriate warnings in relation to the content of what she testified, the prejudice against him, would have been severe, and it would have taken what was clearly a much stronger case against the number two, and it would have clearly strengthened what was a non-existent or at best weak case of circumstantial evidence against the number one. And it is at that point in which we respectfully submit the learned trial judge ought properly to have ordered separate trials. Now, we don't have the benefit of the basis upon which the learned trial judge rejected that submission, but we do have, Your Honor, the manner in which the Court of Appeals sought to treat with it, and that is contained...
Before you get on to the Court of Appeals treatment of it, did the learned judge give a ruling on that issue?
He did. He overruled.
Was it a reasoned ruling?
Well, Your Honor, there was no basis for his ruling. He did not provide a basis upon which he arrived at that ruling. He merely ruled and proceeded. Made a finding that he didn't think there would be prejudice and moved on.
So you didn't get any reasons from him as to
how he arrived at the process. The Court of Appeal, in reviewing that aspect of the trial judge's finding.
Before you go on, did the prosecution oppose the application?
They did. They did.
Did they do so in any written material?
The written material, I'm not sure, Your Honor, but they did articulate their position and the reason why they were opposing. I can't, regrettably, in my fault, say that it was in writing at the moment. I will check.
Do you make a note of what were the reasons why they opposed the application? Or do you recall the grounds on which they opposed the application?
Indeed, Your Honor. They said that no prejudice, any prejudice that may befall the number one could be cured by the appropriate directions of the learned trial judge at the time of the summing up. They also said that it was in the public interest that both accused be tried together and that the circumstances which gave rise to the joint charges arose out of the same set of facts.
Okay. So, and one would have to assume, I suppose, that those were the reasons that the judge gave his decision. On the first issue, you say that the judge did not give the requisite warnings in his summing up. Is that what you say?
Oh, yes, Your Honor. When we come to the inadequacy of the defense, we are very, very strong on that ground. That the learned trial judge gave literally one sentence which purported to be a warning to the jury, and that was the extent of the warning or assistance that he provided to the jury. There was nothing else.
We are then left only with the other two reasons, namely that it was a matter of public importance, that the accused be tried together. Was that it?
Yes, it's a matter of public importance. So the two we tried together. That was one of the reasons, Your Honor.
And the third one was?
That the directions would be, the appropriate directions to the jury.
No, I know. Okay, anyhow, go ahead.
Sorry,
Mr. Hughes, if I may ask, in the circumstances of the prejudice that you describe, could there be any formulation that would take that away?
Oh, Your Honor, you mean if they persisted with a joint trial?
Well, you said, okay, the judge only gave one sentence. So I was just wondering, could you imagine any formulation that would take that particular prejudice in the circumstances away?
No, Your Honor, I think my respectful response to you, Your Honor, is that no, there would not have been a formulation that was available. And the reason I urged that consideration, Your Honor, is the fact that this was not just a co-accused who was implicating the accused. This was a person with whom the co-accused is alleged to have had a conversation. And that witness could only say, this is what was said to her. But the adverse impact of the consequences of what she said in terms of its implication of the accused was so prejudicial. I don't think any direction would have been would have provided the guarantee of a safe trial or of an unfair trial to the number one accused.
Okay, thank you.
Mr. Hughes, before you go on to the Court of Appeal, when Ms. de Nobrega was about to give evidence, was there again an objection to her evidence? And if so, was there any more detail from the judge on how he would approach this matter or handle the directions?
Your Honor, in relation to the second question, the answer is no. In relation to the first question, I believe there was an objection from the defense counsel, which was overruled. I of course, I'm prejudiced because I didn't actually have conduct of the trial, but certainly from the record, there clearly was no, in response to your second question, no.
The objection from defense counsel was as to the propriety of a witness who was a fugitive from the law being allowed to testify and not anything else.
Your Honor, that's a statement, or are you inquiring for me if that was the only ground? That was one of the grounds.
I'm telling you that is all the record shows was taken by way of an objection.
And that would have been, Your Honor, at the time immediately preceding the commencement of her testimony. But they
That is correct.
They did, however, record their objections at the time of the commencement of the trial when they were applying for separate trials. They did state those grounds and the prejudice as one of those grounds.
Thank you, Mr. Hughes.
Thank you, Your Honors. I was going on to invite Your Honor's attention to the manner in which the Court of Appeal attempted to assess this objection. And they said, and this was at line 20 on page, I think, 162, version 3, 47 of version 4, I believe, of the record, where they say, we are of the view, looking at the evidence in totality and having regard to the number of cases on point, that the necessary
Mr. Hughes seems to
I am not hearing you at all, Mr. Hughes.
Yeah, I think he has a technical issue.
He seems to be frozen, President.
Yeah.
President, maybe you could ask Mr. Daniels if he can get in contact with Mr. Hughes, because we may not be able to do that.
Yes, Mr. Daniels.
Oh, if I may, please, Your Honor. It appears that Mr. Hughes is making attempts to get back in.
Are you at a separate location, Mr. Daniels?
Regrettably, we are indeed at separate locations.
Can you call him, Mr. Daniels?
We have placed a call to him, please, Your Honor, and he has indicated that he is signing back in.
Oh, I see. Okay.
Profoundly grateful.
Mr. Daniels, does he require any assistance from us at the court, or he's managing on his own?
I take the liberty of inquiring from him whether he requires any assistance, and I will report accordingly.
Yes, please do that.
Thank you ever so much, Ms. Your Honor.
President, could you, okay, I see he's coming back in.
Yeah, okay.
Your Honors, I'm very sorry. I'm profusely apologetic. I'm not sure what happened. I
That's okay. That's okay. Just go ahead. You were directing us to page 162 of, that's our page 162 of the record, where the Court of Appeal addressed the issue of the joint trial.
Indeed, Your Honor. Sorry, thank you very much. And I was just going to quote what they said, and they, if you permit me a very brief repetition. We are of the view, looking at the evidence in totality and having regard to the number of cases on point, that the necessary ... that no prejudice at the end of the day would have accrued to the applicant in having a joint trial. The trial judge would have given the necessary directions that what was said by one accused was not evidence against the other, and he would have asked...
Stop there. But you said that that was not done.
And I am maintaining that, that's in relation to the trial judge's warning, Your Honor?
Yes.
Yeah, my response to the question was there was one single sentence. One single, not that there was an absent, there was a single sentence that treated with the prejudice of Ms. de Nobrega, which I respectfully submit was significant and required more than a single sentence from the judge that said basically that what she said was not evidence against the accused. That was the extent of his warning and his treatment of that evidence.
Yes.
So in relation to the manner in which the Court of Appeal treated with this, Your Honor, this was not only the testimony of a co-accused, this was not a case, I should say, not only, it was not a case of the testimony of a co-accused against an accused. This was the testimony of a witness who implicated a co-accused. So there was no implication coming from the co-accused against the accused. This is a witness against the co-accused whose evidence was particularly damning in relation to the involvement of the accused. And I respect...
Can you direct us to the page number in the summation that contains that what you say is a single sentence?
Yes, please, Your Honor. That would be, just 1 minute, please. That would be at page, and my page says 110 of 129, where the language of the learned trial judge was as follows. Members of the jury, remember, as I told you before, unless you decide that an accused, any one of them, made a particular remark or statement, you cannot consider it in deciding the case. After such determination, I will remind you also with respect to Jarvis Small that nothing that you accept Bibi Gopaul to have said is evidence against him. And he specifically treats with the evidence of Ms. de Nobrega at line 10 above that. Sorry, not line 10. It would have been... Right, it's at line 25, where he said...
What?
My page at the top, Your Honor, unfortunately says 110 of 129. I'm not sure what the final number is in the overall.
137. It's 137 of our record.
137. Where at line 25, the learned trial judge says, if you believe what she said, it is not evidence against Jarvis Small. It is a simple rule. The evidence of one accused or the statement of one accused is not evidence against the other. And that was the extent of his treatment. He went on in the following sentence to say, the same applies to Jarvis Small. If you find anything in the course of the evidence that he said that affects her, you may not use it. And that was the extent of the warning to the jury in relation to the testimony of Ms. de Nobrega. So there were the two aspects of that I invite the court to look at. One, the testimony of Ms. de Nobrega was not the testimony of a co-accused. This was the testimony of a witness against the co-accused, and therefore could not be treated as the testimony of the co-accused. And secondly, because of the highly prejudicial nature of what she said, particularly insofar as the content and the implication of the accused, Mr. Small, is concerned, insofar as it implicates Mr. Small is concerned, even though a trial judge, which he did not do in this case, said that, look, this is not evidence, they ought properly to have said, first of all, this is just a statement against the co-accused, and nothing in there can remotely constitute evidence against the accused, Mr. Small. And that, I respectfully, sorry, Your Honor.
You can move off of that issue now, Mr.
Sorry, I certainly will. Your Honor, the other point that I wanted to urge for Your Honor's consideration was that even if, and I will close off with that, even if highly prejudicial material in relation to the allegation of sexual misconduct made by the deceased against the accused was admitted into evidence, and even if Your Honors were to find, and we strongly will argue that it ought not to have been permitted, allowed in, because there was a denial, or I should say a retraction of that evidence. But even if that was admitted into evidence, that coupled with the testimony of Mr. Nobrega placed such an obligation on the learned trial judge to ensure that the adverse consequences, or prejudice, I should say, not consequences, the adverse consequence, prejudice to Mr. Small ought to have been brought to the attention of the jury with the appropriate warnings and guidance as to how they should treat with that point. And that was not done by the learned trial judge. The learned trial judge, Your Honor, was very, very scant, if I say that with respect, in addressing the defense, which is coupled with the absence of warnings. And I will merge the two for the sake of brevity. The learned trial judge essentially treated the defense of the number one accused as one in which he was merely pointing out inconsistencies in the prosecution's case. And it was a lot more than that, and ought properly to have been treated a lot more than that, Your Honor. And for this reason: one, the defense of the number one accused was he did not do it. It wasn't a case of him just merely pointing out the fact that there were difficulties with the prosecution's case. It was a complete denial. And if I could invite Your Honors to the way in which the learned trial judge sought to portray this defense in putting the defense's case. That is set out at page 116 of 129 in my record, and it's very brief, where the learned trial judge says, Mr. Jarvis Small's defense is saying, look, you cannot rely on the evidence of the police investigators because they're inconsistent with their individual testimonies and discrepancies with each other. It is my respectful submission, Your Honor, that the defense was more than that. The defense was simply he did not do it. And even if you took all of these bits of evidence that amounted at highest to suspicion into account, the learned trial judge, in putting the defense, ought properly to have listed and warned against the prejudices that arose against the number one accused as a result of Nisha Gopaul's evidence, and as a result of any evidence that existed on the record against the number two not being used against the accused, Mr. Small. And that was not done at any stage of the defense. As a matter of fact,
we're not hearing you, Mr. Hughes.
My apologies. I was saying, Your Honor, that the learned trial judge, in putting the defense of Mr. Small to the jury, literally spent 2 pages, or I should say 1.5 pages of substance, addressing the defense, and none of them included at any stage any warning about the prejudices that would be occasioned to his defense as a result of the testimony of Mr. Nobrega. and it did not arise at any point during the prosecution's his presentation of the prosecution's case. And it is my respectful submission that where there was such a grave prejudice acknowledged by the court when he overruled the application for a joint trial, that it was incumbent upon the court, having realized and recognized that significant prejudice, to have spent a considerable amount of time identifying what the potential prejudice was and then assisting the jury in how to treat with it. So none of this takes place. So it is not even a case where there was an attempt to treat with it. There was merely that bold statement, which I referred to earlier, where he said that the evidence can't be used against him. But in the defense, he doesn't even attempt to identify this statement is prejudice. For example, Ms. de Nobrega says that the number 2 accused told her that this incident took place in the car and that the young lady was very brutally assaulted in the car. Nowhere does the trial judge in his defense say, even though this is what was said, you cannot use this against Mr. Small. And that, Your Honor, assuming that the court were unpersuaded by my arguments that there should not have been a joint trial, the fact that there was a joint trial meant that the trial judge was obliged, doubly obliged, if I may use that term, to deal with those aspects of the prejudicial evidence, just to ensure that when the jury considered the evidence, they had the appropriate warnings from the judge about the dangers of that evidence. And there was no attempt at any stage to do that. As a matter of fact, the Court of Appeal acknowledged this, and in a very curious statement, if I may, invite Your Honors to look at the way in which the Court of Appeal acknowledged this. And this is contained at page 172 of 196, line 11 of their decision, where they say, now, ideally, the trial judge should have dealt with each and every aspect of the statements made by the applicants from the dock. The jury, nevertheless, would have heard all of the evidence and would not have been misled by the failure of the trial judge to deal with each and every aspect. We hasten to add that the salient aspects which arose in relation to the defense must be treated by the trial judge. The defense in this case, however, was a denial of the prosecution's case and in itself was placed before the jury. So I believe there was a very, very erroneous conflation of several issues there in which the Court of Appeal either did not address or wrongly considered the legal principles. Because the fact that they said, forgive the repetition, the jury nevertheless would have heard the evidence. The issue is not whether they heard the evidence. The issue was whether they got the appropriate guidance in relation to the nature of the evidence, particularly of Mr. Nobrega. And they go on to make the assumption, would not have been misled by the failure of the trial judge. So in other words, they're saying that the trial judge failed to deal with these points, but despite the failure of the trial judge to deal with these points, the jury would not have been misled. Well, I believe, Your Honor, that is particularly erroneous in terms of the reasoning that is applicable there, because the entire purpose of the trial judge, forgive me for stating the obvious, in a criminal trial is to assist the jury in how they are to assess that evidence. So if the court says that, look, even if the trial judge did not deal with these points, the jury must have heard it. That, I believe, Your Honor, is perhaps the most egregious assault upon the possibility of a fair.
You're going to mute again.
I'm sorry, Your Honor. My apology. I will change my equipment after this. Your Honor, I was saying the assumption by the Court of Appeal that the evidence was before the jury, therefore, the absence or the failure of the trial judge to deal with it didn't affect the case, actually supports the complaint that we are making, the fact that which is that the salient points and particularly the prejudice that was occasioned to the accused, Mr. Small, was never addressed by the trial judge. And the fact that there was a denial of the prosecution's case is not a basis for the Court of Appeal to arrive at the assumption that that relieved the trial judge of the responsibility to treat with the prejudicial material against the accused. The Court of Appeal went on, and forgive me, we believe the salient issues would have been placed before the jury. I don't know how the court could properly say would have been placed. There was no evidence that the salient issues were placed before the jury, and they continue, quote, albeit not every iota of the statement or every iota, ASP, not every aspect of the statement would have been highlighted to the jury. Well, Your Honor, I believe there's another error there by the Court of Appeal. It's not whether the statements of the accused in their defense were highlighted. It was the question of whether the prejudice occasioned to the accused by the testimony of Ms. de Nobrega was treated with at all, other than a single sentence saying that it could not have been used against him. The jury would have heard the statements of the appellant, and at the end of the day, it was for their determination whether they accepted the defense of the applicants that they did not commit the offenses charged. But Your Honor, with the greatest respect to the court, I believe that highlights the particular risk and prejudice that the accused was, through counsel, was making at the commencement when they applied for separate trial, and being assured by the court that the appropriate directions would be given, and at the end of the day, no such directions were given. I believe that the Court of Appeal fell into serious error where they say the jury would have heard the statements by the appellants. The issue is not the statement by the appellants. The issue here is whether the testimony of Mr. Nobrega, which the jury heard, not would have heard, was ever addressed in any manner whatsoever by the learned trial judge. And in those circumstances, in the absence of it being addressed, there was a grave prejudice to the accused person. And we respectfully submit, Your Honor, that the inadequacy of the defense, i.e. they merely treated, the learned trial judge merely treated it as the accused attacking the inconsistencies of the prosecution's case, coupled with the absence of any assistance from the learned trial judge, particularly in relation to highly prejudicial evidence, not from a co-accused, but from a witness who implicated a co-accused and whose testimony couldn't be used for the truth of the content, that there clearly was a complete miscarriage of justice in relation to the number one accused. The Court of Appeal then, of course, attempted to apply Section 13 of the Court of Appeal Act. And they said, at line 16 of page 173 of 196, we've considered whether before there would have been any substantial miscarriage of justice so that it would be inappropriate for us to apply the proviso. We rely on Hardet Kitwaru and the state and Alexander and the Queen. It's a recent decision of the Court of Appeal. We believe the application of the proviso to Section 13 of the Court of Appeal is appropriate, and we find no substantial miscarriage of justice given the errors we would have highlighted. So the court confirms the errors of the learned trial judge. They confirm those errors. They themselves confirm that the salient points were necessary, but they may not have been addressed by the learned trial judge. But this, having confirmed that, arrive at a conclusion that no miscarriage of justice was occasioned. And we respectfully submit, Your Honor, that regrettably, I don't think that given the sequence and the, forgive me for using the term logics of the way in which the approach of the learned trial judge, or the absence of the appropriate approach by the learned trial judge, that would not have resulted in a substantial miscarriage of justice. Because the court here confirms that there were errors. So the issue is not that there were not errors. They confirm that there was a risk of prejudice and that they ought to have been directions. They confirm that the points that ought to have been taken were not taken by the learned trial judge. And they arrive at the conclusion that despite these grave errors committed by the learned trial judge, there was no miscarriage of justice in a case where it was not even the testimony of a co-accused, it was the testimony of a witness who said the co-accused had a conversation with her. And it is our respectful submission, Your Honor, that perhaps occasioned the greatest miscarriage of justice and resulted in a conviction where even if the court were of the opinion that all the evidence of prior allegations of sexual misconduct were properly admitted, that this resulted in a miscarriage of justice. The final point I would urge the court to consider is the question of the allegations that were raised by the deceased of inappropriate sexual contact and by the accused, which were withdrawn and which the police witnesses confirmed were withdrawn. One, the first time by an affidavit by the actual victim, deceased, and on the second occasion, a statement by the mother of deceased to the superintendent that the report that had been made the day before was withdrawn. That evidence, I respectfully submit, ought not properly to have been allowed in. The prosecution seek to argue that this was an attempt to put context to the relationship and consequent death of Nisha Gopaul. But the prejudice occasioned by that is, of course, one, there clearly was an allegation that there had been sexual misconduct by the accused, which is highly prejudicial. And that allegation was withdrawn. First allegation placed, withdrawn. Second allegation placed, withdrawn. So for the learned trial judge to have permitted this, which clearly would be highly prejudicial, there was no suggestion that the death of Ms. Gopaul was preceded by any form of sexual activity or inappropriate sexual activity or criminal sexual activity by the accused. So the prejudice occasioned to him by the admission of that evidence, Your Honor, I would respectfully submit is significant, given that there were the withdrawals. And the learned trial judge, in his address to the jury, referred to it, but did not assist the jury with the weight, if any, or the significance of the fact that they were withdrawn. And the consequence of the withdrawal was that there was no pending allegation, or that no reliance could have been placed on the fact that an incident had happened merely because there had been an accusation and a complaint made to the police. Those, Your Honors, are the points, in addition, of course, to the submissions that we have laid over with you, that I believe are perhaps, in our humble opinion, irreparable because of the impact they would have had on the possibility of an acquittal for the number one accused. My learned friend, sorry, Your Honor.
Yeah, Mr. Hughes. Well, the least that evidence about the complaints and the withdrawal of the complaints, the least it shows is that all was not well within that household. That I mean, you're not. So it doesn't prove anything about sexual abuse, but the fact that the complaint is made and withdrawn and then again made shows at least that there was something wrong in that particular household. So personally, I don't see what's so wrong about it. But anyway, coming back to the first point, I think that is all about fairness. But I'm also interested in sufficiency of evidence, which may be even more important. But that might be my civilian look at things. And everybody seems to agree, everybody agrees that statement, that evidence of Mr. de Nobrega could not be used against your client. And as you started to say, and that's another way of looking at it, as you started to say, so what's left of the evidence? And you are saying, if I understand you correctly, that is totally insufficient for any conviction. So that's another way of approaching it, I would say. And if I understand you correctly, you are saying in your written submissions too, that for that reason, the judge should at least have honored the no case submission because there was really nothing to go forward on. Is that exactly what you are saying?
That is precisely what I am saying, Your Honor. Forgive me, I didn't seek to repeat what I've included at paragraph 14 of our submissions, which is at the end of the day, you had the untested reports, and I agree completely. I do not seek to contest that all was not well in that household, and that is appropriate evidence that could have been left to the jury. But you had that evidence, a statement that he did not kill the accused. You had that he was the owner of the dumbbells, that the dumbbells were found with the suitcase, and that he was in a hotel room with the mother of the victim the day after she was reported missing. That, I respectfully submit, forgive the repetition, as set out in our written submissions, could not have been properly left to the jury.
Thank you.
Your Honor, I believe you're muted. I'm unable to hear you.
Yes.
I said thank you.
No,
His Honor Justice Saunders was muted, I believe.
Yes, that's great. That's the end of your submissions. You said Mr. Daniels would address us on the sentencing aspect?
Yes, please, Your Honor.
Yes. Mr. Daniels?
Very good morning to Your Honors. By Your Honor's kind leave, might I respectfully proceed?
Yes, please do.
Profoundly grateful. If I may please, Your Honors, we preface our invitation to the Honorable Court to revisit the sentencing as handed down by the Court of Appeal by inviting the Honorable Court to consider the approach that the Court of Appeal properly should have taken, having regard to the prescription enunciated at paragraph 16 of Ramcharan, when the Honorable Court identified 4 considerations that the Court of Appeal should have in reviewing sentences. And those are: 1, to ensure that the principles of sentencing are properly applied; 2, to ensure that sentences are not demonstrably unfit or unjust; 3, to provide clarity and guidance to lower courts; and 4, to help to develop the law, including in directions that appropriately respond to evolving notions of justice. The Court of Appeal did agree with the submissions of learned counsel for the appellant that the learned trial judge did not give any breakdown of the sentence or the matters that the learned trial judge considered in arriving at the sentence. The Court of Appeal as a matter of fact, said, please, Your Honor, at page 174 of the Record of Appeal before the Honorable Court. From line 10, we are of the view that the trial judge erred in his consideration of the sentencing principles as well as the sentence imposed. We believe that the trial judge gave no analysis of the starting point of 60 years, how he arrived at it, and neither did the trial judge give any indication as to the fact that whatever considerations that were mitigating to the offense, as well as to the offenders, the Court of Appeal went on to revisit the sentence, having regard to the sentencing methodology that properly should have been employed in view of the dicta in Linton Pompey and the state, please, Your Honors. And we fancy that the Court of Appeal found itself in the position that the court in Ramcharan articulated in the introductory paragraphs, particularly at paragraph just a moment, please, Your Honor. Particularly at paragraph 3 of page 3 of Ramcharan. When the Honorable Court said, and I quote, "The deficits are arguably so fundamental that evidently it is difficult for an appellate court to engage a thorough resentencing review and arrive at an appropriate new sentence to overcome these evidential deficiencies. This matter can be remitted for a sentencing rehearing, guided by this court's jurisprudence, including as set out in this opinion and in the majority opinions in Pompey. However, given the passage of time from both the date of the crime and the holding of the sentencing hearing, and in the interest of fairness, timeliness, and for other pragmatic reasons, this sentencing re-evaluation and reconsideration ought not to be remitted for rehearing. It must now be undertaken." So we submit that this is a position that the Court of Appeal fancied itself to be in, having regard to revisiting the sentence, the sentence handed down by the learned trial judge in the instant case. But to respectfully submit, please, Your Honor, that the Court of Appeal, being alive to the methodology in Pompey, did not follow the methodology in Pompey. The methodology as contemplated by Pompey and reinforced in Ramcharan at paragraph 125 of Ramcharan, when the honors of the Caribbean Court of Justice said, and I quote, "As explained in Pompey, a rational process for sentencing includes following the methodology for establishing sentencing starting points. And a critical part of this exercise, which contextualizes it and also also includes evidence of prevalence and seriousness and trends in these elements in a particular jurisdiction or in a subregion of the territory." End of quote. The Court of Appeal simply said, please, Your Honors, and I quote from paragraph, from line 3, of page 175 of the Record of Appeal. When the Court of Appeal said, and I quote, "Doing the best we can in the circumstances of this case, rather than sending this case back for a consideration of the sentence, we're considering the factors as adumbrated in Aguilera and the state and Tirret and the state, and 2 recent decisions from this case properly should be this court, one given yesterday and one given last month." And then the court went on to address factors it was taken into consideration to arrive at the starting point. We respectfully submit, please, Your Honors, that the Court of Appeal did not employ the methodology contemplated by Linton Pompey and the state and Ramcharan and the DPP. The Court of Appeal merely referred to the approach taken by Aguilera without directing its mind specifically to what considerations in Aguilera it was having regard to. And I'm minded, please, Your Honor, to visit the considerations contemplated by Aguilera in arriving at the starting point, particularly at paragraph 19 of Aguilera, when the court quoted with favor from the state and Toiki, if I'm pronouncing that correctly, Toiki, Ridley, and Roberts, which is a 2005 New Zealand case, please, Your Honor. And quoting from paragraph 28 of Roberts, the court said, and I quote, setting the appropriate starting point for sentencing will involve an assessment of a number of features which add to or reduce the seriousness of the conduct and the criminality involved. As this court noted in Mako, it is the particular combination of those variable features which requires assessment for sentencing in each case. The court went on to say, the task of placing the particular combination of features comprising an offense in its proper relative position on the scale of seriousness is a matter of judgment, calling for the careful exercise of the sentencing discretion. Features of the offending requiring assessment, cannot be exhaustively listed. End of quote. The court further quoted with favor just a moment, please, Your Honors. Paragraph 43 from the said judgment, and I quote, to achieve the objective of greater consistency, it will be necessary for sentencing judges to articulate in a transparent way the basis upon which they have determined the appropriate band and the factors which have guided their assessment of the starting point. It will be important that the starting point is identified before attention is turned to the personal circumstances of the offender, because a starting point will provide the basis for assessing the consistency of one case with another. End of quote, please, Your Honors. I respectfully submit that the prescriptions in all of the cases, Aguilera, Pompey, and Ramcharan, is that the court must engage in what is tantamount to a forensic exercise in arriving at that starting point. And we do not see that emanating from the judgment of the Court of Appeal, please, Your Honors. The Court of Appeal simply referred to Aguilera and Tirat Prasad in rather broad terms. And then the Court of Appeal went on to address factors which it has taken into consideration to arrive at that starting point. Even the two recent decisions referred to by the Court of Appeal emanating from the Court of Appeal, no mention was made of the names of those decisions, no mention was made of the sentences in those decisions, no mention was made of the starting point in those decisions, and certainly no mention was made of the factors that the court had regard to in those decisions in order to inform the starting point of 35 years it arrived at in the instant case, please, Your Honor. And certainly no mention was made of any cases across the spectrum of the Court of Appeal or of the lower courts in Guyana, and neither any of the subregions. The Court of Appeal proceeded to contemplate, and we dare say what
Mr.
appears...
Daniels, can I just interrupt you?
Certainly,
I know you criticizing the Court of Appeal's judgment, but did the attorneys render any assistance in this regard? That is to say, to supply the Court of Appeal with the comparable cases and material factors from those comparable cases, etc., to assist it in determining either a starting range or a starting point?
I cannot say, please, Your Honor, that the attorneys on either side, please, Your Honor, in a comprehensive or meticulous way assisted the Court of Appeal in that regard. I cannot matter of factly say that.
You mean they did not, or you do not know whether they did?
I do not think they did in a comprehensive way, please, Your Honor.
Okay. All right, thank you.
Grateful, please, Your Honor. We're certainly minded, please, Your Honors, that Ramcharan and Pompey as well dealt with sexual offenses and not murder. We cite Ramcharan and Pompey not for the starting point that was eventually arrived at, but for the methodology in arriving at the starting point, please, Your Honors. And the factors that the Court of Appeal considered in the instant case, and I quote from line 6 of page 175 of the Record of Appeal, applying those factors relevant to the offense, we believe that a starting point of 35 years is appropriate for the following reasons. The age of the deceased, as we said, the deceased being a child, the offense was committed by persons who were close to the child. The violence used as mentioned by the doctor, Dr. Niall Singh in the postmortem report and his viva voce testimony, amount to violence used, and the method of disposal of this child. The fact that this child was known to or was related to the appellant, which we think respectfully is another consideration of the same factor as considered at line 9. The offense was committed by persons who were close to the child. The persons close to the child respectfully would have been known to or related to the child in some way. We look at the factors relevant to the offender. Now, the Court of Appeal departed there from looking at the factors exclusively relative to the offense, as properly should be considered to arrive at the starting point, before looking at the factors relative to the offender in order to determine whether that starting point would be varied upwards or downwards. And that is why we say respectfully that the considerations insofar as the starting point is concerned seem to be conflated. And the Court of Appeal went on to say, and I quote, the number one appellant, Jarvis Small, was 45 years at the time. The number 2, Bibi Gopaul, was 45 years too at the said time. We look at Jarvis Small, the age difference between him and the child, the fact that he had access to the child in her home, and the motive based on the allegations against him by the child. We look to see whether there was any mitigating factors. We see no record of any remorse in that regard from any record in the evidence by the trial judge, by any of the appellants. And then the court went on to deal with factors touching and concerning.
Mr. Daniels, sorry to interrupt you again, but I'm just looking at your submissions again. I think it's from paragraphs 59 on, when you deal with ground 12. Correct me, but it doesn't appear to me that in your written submissions you have engaged the process that you recommend the Court of Appeal should have. That is to say, to give us the assistance that would help us determine an appropriate range or starting point. Have you? You've cited 2 cases, Vinod Balgobin and Rupert Brown, as examples of ad hoc sentencing, i.e., one in which a relatively high, and you know what I mean? Have you placed before us? I mean, this submission on sentencing by you is on an assumption that we don't agree with what Mr. Hughes may have said, and so you are criticizing the Court of Appeal in its approach to sentencing. We've heard you, we've read the submissions, but have you given us the assistance for us to apply the principles which you say the Court of Appeal should have applied, it having engaged effectively on a rehearing for us to apply these principles and come up with an appropriate sentence? Have you given us that assistance?
I would have to respectfully, please, Your Honor, accept that on the face of our submissions, we have not assisted the court in that regard. I cannot. I humbly and respectfully cannot escape from that, having regard to what appears in the face of our submissions.
Yes, so well, I just think that if that is the basis of your criticism of the Court of Appeal and you want to assist us, as I'm sure you do, then what you should also be doing, in addition to criticizing the Court of Appeal, that's your client's right, and we appreciate that, you should also be giving us the assistance so that if we reach this stage in relation to the accused Small, we can say, well, all right, these are comparable cases, this is a range, this is an appropriate starting point, because as Mr. Daniels has pointed out, A, B, or C, you know what I mean? And then we then look at the circumstances of the accused, stage 2, aggravating, mitigating, and then, well, the discount for time served, right? This, you know, so maybe you will undertake at the end of this hearing, within a period that you will maybe offer to help us with that, will you?
Certainly, please, Your Honor, and I'm profoundly grateful by the courtesy extended by Your Honor.
It's for the president to decide the timetabling, but I'm really raising for your attention that I think as a matter of principle, if you come before us on a point like this and you're going to criticize the Court of Appeal and ask us to overturn what the Court of Appeal has done, then you should give us the information, and I'm happy that you agree. So thank you.
Mr. Daniels?
Do forgive me, please, Your Honor.
Yeah, go ahead, Justice Barrow.
Mr. Daniels, you're not having done what my brother said was obviously significantly missing. Is there any more that you can do to assist us in oral submission?
Well, not as respects, please, Your Honor, the provision of statistics and drawing from those statistics, please, Your Honor, what properly should be the starting point on the face of those statistics, please, Your Honor. To that extent, I am respectfully unable to assist, Your Honor.
Yeah, okay. The short issue is if you thought 35 years was not an appropriate starting point, what was?
If I may please, Your Honor, the parameters within which sentencing for murder properly should be undertaken in Guyana pursuant to Section 100A 1B of the Criminal Law Offences Act stipulates that the minimum sentence is 15 years of imprisonment, please, Your Honor. And the accused, of course, can be sentenced to life imprisonment. And life imprisonment, please, Your Honor, has been determined by the Honorable Court if I may please, Your Honor, I would submit respectfully that perhaps a starting point of 30 years.
Yes, okay, thank you.
Got it, please, Your Honor.
Mr. Daniels, reading through the reasons that the Court of Appeal gave, I assume then that Mr. Small had no previous convictions?
Mr. Small had no previous convictions, please, Your Honor, and it does not appear on the face of the decision that that was expressly considered.
No, so that's why I'm saying if he had, then I assume they would have mentioned it, but just to be sure. Thank you.
Got it, please, Your Honor.
Yes, is that the extent of your submissions, Mr. Daniels?
There are just two rather brief points, two rather brief considerations I would respectfully invite Your Honors to have regard to before I close. And that is the jurisprudential development as articulated in Ramcharan at paragraph 25. The approach that should be taken to sentencing, please, Your Honor. And I quote, please, Your Honor, Justices Witt and Anderson considered the conditions in the prisons to be relevant in sentencing, as these conditions have an impact on the severity of the penalty. The dissenting judges concluded by stating that the law appears to be at the beginning of a jurisprudential development which explores whether unduly long terms of imprisonment violate fundamental rights embodied in several human rights treaties. This development appears to be coinciding with lower sentences imposed for even the most heinous offenses, including murder and rape. The unthinking imposition of excessively long sentences is usually counterproductive. When eventually a broken and embittered convict is released into society and should be avoided. End of quote, please, Your Honor. And just one final point on the contemporary approach to sentencing. When the Your Honors said at paragraph 100 of Ramcharan that the contemporary approach to sentencing is away from an overemphasis on punishment and vengeance, retribution, and to focus more on rehabilitation, restoration, protection, and peace. This approach confirms the necessity for separate, relevant, research-based, and competently informed sentencing hearing. I would humbly invite Your Honor to have regard to those considerations as we invite Your Honors to review the sentencing methodology deployed herein and the sentencing arrived at. Thank you ever so kindly, please, Your Honors.
Yes, thank you. Who's representing Ms. Gopaul?
Good morning, Your Honors.
Yes.
I'm respectfully appearing for Ms. Gopaul Arudranath Gosai. Your Honors, I intend to rely on my written submissions as well as my submissions in reply to the submissions of the Lorne DPP in answer to my submissions. But I wish to just highlight a few points for the consideration of Your Honors in this appeal. Now, Your Honors, in relation to the appellant Gopaul, the narrow issue that was before the Court of Appeal and the narrow issue that is before Your Honor's Court is the issue of the evidence of the Nobriga, the cellmate who gave evidence that Gopaul allegedly told her a story. The challenge in the Court of Appeal mounted by the appellant Gopaul was that the judge failed fundamentally to highlight the necessary indicators that will trigger a warning in relation to evidence given by a cellmate. So in the summing up, please, Your Honors, the Lorne trial judge said that the jury need to be needful. That is a word that is recorded in the summing up, please, Your Honors, that the jury must be needful when they act on the evidence of the Nobriga, for the reason that the Nobriga was at the time facing several charges of obtaining by false pretenses, and that they should be needful. Now, Your Honors, there were other indicators other than the mere charges alone that the Lorne trial judge alluded to. And those indicators were, by way of example, Your Honors, that Dinabriga herself in her evidence admitted that she was convicted in relation to some of those offenses. That is at page 372 or 463 of the record in Criminal Appeal number 4. That is the record in Bibi Gopaul's appeal. So no mention was made of that fact to the jury by the learned trial judge. And we're saying respectfully that that was a fundamental flaw in the summing up by the learned trial judge. Now, the learned trial judge, in addition to saying you need to be needful, and that is at page 459 or 463 of the record. The learned trial judge went on at lines 1 to 8 of page 459, in addition to saying that that at the time she told the police the story, she was not a convicted prisoner. She was there awaiting trial on charges. But that was not the evidence that was given by Dinabriga herself, because Dinabriga at page 372 of the record indicated that she was convicted of some of those offenses. Now, it was important, please, Your Honors, for the learned trial judge to have highlighted that fact, because the charges were charges of a dishonest character. And so it was crucial for the learned trial judge to point out that not only that this witness was facing charges of offenses of a dishonest nature, but that she was in fact convicted of some of those offenses. The witness herself said that. The learned trial judge at lines 10 to 15 of page 459 of the record then told the jury, members of the jury, you will need to be needful when considering this evidence. You have to first consider whether you believe Bibi Gopaul told Dinabriga this story before you accept it. And if you accept that she did tell her the story, then you have to determine whether you feel sure that the contents of the story is true before you can act on it. Now, Your Honors, fundamentally, we are saying respectfully, the learned trial judge should have gone on there to give the warning, to say you can accept it. But you have to be careful before you act on this evidence of Dinabriga, because one, she's facing multiple charges of a dishonest nature, and two, she was convicted of some of those offenses. In addition to that, Your Honors, Dinabriga in her evidence stated that she had two sons and she did not want to, my sons are 10 and 14 years old, page 376 of the record, please, Your Honors. I don't want to be imprisoned away from these two sons, these two young children. At the same page 376, Dinabriga goes on to say, I have been going to the police station for dishonest transactions for a couple of years. That again, the learned trial judge ought to have pointed out those indicators to the jury, but failed to do so, failed fundamentally to do so, please, Your Honors. And we had submitted in the Court of Appeal, and we are submitting before Your Honors, that the failure to do so rendered the conviction unsafe. And so the only decision that the Court of Appeal ought to have made was to uphold the appeal against conviction and set aside that conviction.
Help me
now,
here, Mr. Gosai.
Yes, please, Your Honor.
The thought is just coming to me as you're making the submission, so I have obviously not thought it out at all, but are you engaging in a bit of similar fact evidence?
Well, no, please, Your Honor.
No, but in relation to Ms. Dinabriga, that she being a person known for dishonesty, convicted, the judge should have said to the jury, she, known for dishonesty, is a person whom you must consider whether she has a propensity for dishonesty in other matters and therefore may be dishonest in what she says Bibi told her. Is that what you're saying?
That is the submission I'm making insofar as it relates to the warning, please, Your Honors. That is the kind of language that the learned trial judge ought to have brought to the jury's attention in relation to treating with the evidence of the Nobrega.
But can that be done in relation to an accused person? Let's deal with similar fact in itself, not in relation now to the Nobrega, but yes, similar fact in itself. The proposition why similar fact evidence is generally not acceptable is that the jury may not be told that because this person has a propensity for committing crime, he must have committed the crime in this instance. What you are asking, or what you are saying the judge ought to have done, was to have done that very thing, to say to the jury, this person has a propensity for dishonesty, and therefore you may believe that she is being dishonest in this instance. I am just puzzled.
That is what I'm saying, please, Your Honor, that the judge, given the convictions as well, that there was more than enough information or evidence before the learned trial judge for him to have come to that conclusion, quote unquote, and give that warning that this is a witness who charged, convicted, so you have to be careful on this occasion as to whether she is in fact telling the truth or not telling the truth. Now, Your Honors, the Court of Appeal agreed.
Mr. Gosai,
yes, please.
Before
yes,
you continue, I read through that part of the statement. I seem to remember that was a point of, well, any defense lawyer would put that into cross-examination, that making that point that she could not be trusted. Is that so?
It wasn't done as far as the record goes in terms of the cross-examination, but at the beginning of, prior to the Nobrega taking the oath to testify, defense counsel then for Ms. Gopaul did indicate, I can't say it's by way of an objection, but at page 3, defense counsel at the beginning had indicated that the evidence ought not to be given because of the dishonest character of the intended witness at that time. But that was all that was said by defense counsel in relation to, if I use that to answer your honest question, but there wasn't any direct challenge in cross-examination. For example, to suggest to the witness that you should not be believed, you're a person of a dishonest character, these are evidence of offenses of dishonesty and whatever the case may be.
That was not done.
No, please, Your Honors.
Thank you.
Mr. Gosai, what was the approach of the Court of Appeal on the submission that you're making to us now?
I was getting to that, please, Your Honors. Thank you very much. The Court of Appeal in the transcript of its decision agreed. In fact, the learned chancellor who delivered the judgment of the Court of Appeal agreed that the learned trial judge ought to have used other word other than any other word, may be careful, other than the word needful. The learned chancellor and the Court of Appeal also agreed that the learned trial judge ought to have given the warning, failed to do so. The Court of Appeal agreed that the learned trial judge failed to give the appropriate warning. That's at page 46 of 60 of the record, please, Your Honors. And if I may briefly, the Court of Appeal was saying the word needful does not appear to be the word to have been used by the trial judge. It would appear that the word that should have been recorded or should have been used would have been the word careful, because the word needful does not fit in the context of the case.
Does everyone in Guyana know what needful means?
I actually came across the use of the word when I was going through the summing up. So I checked the word, the meaning. I haven't heard it used in a statement in Guyana prior to that occasion.
Mr. Gosai, may I interject here?
Yes,
the
please,
passage that you read it seems to me that the Court of Appeal was saying that that which appears in the transcript is not the word that they believe the trial judge used. The Court of Appeal seems to be saying that what is recorded in the transcript is not the word that they believe the trial judge used because it doesn't fit in.
I understand what Your Honor is saying, but when I read the line 4 to 6 of the Court of Appeal decision, page 46 of the record, they said, of course, that it would appear that the word that should have been recorded or should have been used. So even the Court of Appeal was not clear as to whether it was an incorrect record of what the judge said or whether the judge in fact did say it.
So the word that should have been recorded. So I think we are at one. The Court of Appeal is not accepting that it was needful that was the word used. They're saying that they're holding it open, that that is an incorrect recording. Yeah?
I hear Your Honors, please. But the Court of Appeal went on to say it was the word that should have been or should have been used. And when Your Honors consider the length of this discussion, it would appear that the Court of Appeal formed the view that the word needful was used, because when they go on, they say they give a definition of needful, and then they say that the issue then would be whether the jury might have been misled if the word needful was used or whether the word careful was used. So I don't believe respectfully that the Court of Appeal came to any conclusion as to what was the word that was used by the learned trial judge.
And with respect, Mr. Gosai, I fully agree with you. They did not come to any conclusion. They simply held it open.
Yes, please, Your Honors. But we are saying that what is on the record as being said by the learned trial judge to the jury is that they must be needful. Assuming that even if the learned trial judge said you must be careful, we are still saying that that alone would not have been sufficient to just indicate to the jury the Nobrega is facing multiple charges of obtaining by false pretenses. You must be careful when you act on that evidence. We are saying that the directions ought to have gone on further than that, not just to say be careful of what? And to adopt the words of His Honor Justice Witt, that go on to say that this can be and Your Honor Justice Barrow as well, that it could be a situation where the jury need to be informed that because this is a witness who is facing charges of dishonest nature, this might be an occasion when she is not telling the truth. So that even if the word careful alone was used, we are still submitting respectfully that that still would have fundamentally fell short of what was required by the learned judge in this instance. Especially so, please, Your Honors, when this was the only material evidence connecting the appellant's Gopaul to the alleged commission of this crime. So that
Mr. Gosai,
yes,
do you want to go that far? That this was the only material evidence? Really?
Your Honors, the other bits,
the red rope, the bank book, the other documentation, the dumbbells which were located at her house. There was physical evidence which connected things owned and located at Ms. Gopaul's house with the murder.
Yes, please, Your Honor. And even in relation to that, please, Your Honors, the learned trial judge also made a fundamental error in relation to those aspects of the evidence. By way of example, police officer Ned indicated that he collected more than 10 items from the home to test for blood and whatever else. Ned indicated that despite several checks, requests from the lab to get back the results of the tests, it was not successful. He did not get the results. The learned trial judge, in his summing up, did highlight that to the jury. But in the evidence of the analyst, Mr. Caesar, he indicated that he tested these and they prove negative for any blood or any blood on these items. Now, again, Your Honor, respectfully, this is something that the learned trial judge, even dealing with the other evidence, which may or may not connect the appellant Gopaul to the crime, that in the summing up, the learned trial judge left it hanging in the air as though the samples were taken, samples were lodged at the page 264 of the record. And that would be Your Honor's, indulge me, Your Honor. That would be Your Honor's page 328 of 365. I'm just going on, Your Honors, to make this point about the other evidence that sees the Stephen Graves, who was the analyst at the time, at page 328 of Your Honor's record.
Mr.
I
Gosai,
found, yes, please, Your Honor.
please permit me to interrupt you. I
Very
know
well, Your Honor.
it could be considered bad manners in instances, but perhaps we may save time. I'm not asking about the things which did not provide any result, you know. So to tell me that the judge indicated or did not deal properly with the fact that the witness who testified said that there were negative results in relation to certain aspects of the evidence, I don't know that that assists the observation which I made to you at all. You were saying that the Dobrega's evidence was the only objective evidence against Ms. Gopaul. And I'm suggesting to you that there were these other things. And what you have done, I mentioned, I think, 3 things. You have mentioned to me a 4th thing, and you have now focused on that 4th thing, which we both agree does not have any probative effect. But I'm saying to you that there are the other 3 things: the dumbbell at her house, the rope, the red rope, and the documentation that, as the prosecution put it, only a mother would have in relation to a 16-year-old child. So I'm just saying to you that there was other evidence. That's all I'm saying to you.
That is accepted, Your Honors. What I was probably going on to do by jumping the gun was to address that other evidence, but I will do that subsequently.
And the point is, it's a non-point, Mr. Gosai. That's what I'm saying to you. The other evidence which proved to be negative, you cannot make any submission in relation to that. It doesn't prove anything.
Indeed, Your Honors, I agree fully. So, Your Honors, but we're saying that the whole thrust of the state's case relied heavily on the evidence of the Nobrega. Now, within the evidence of the Nobrega itself was in our respectful submission, the prejudicial evidence of the appellant Gopaul confessing to the Nobrega that on a prior occasion, she and the appellant Small had conspired together and caused the death of Gopaul's husband. Now, at the beginning of the trial, defense counsel for the number 1 appellant, Mr. Small, the appellant Small, objected to the leading of that evidence insofar as it relates to Small. The state accepted that the evidence can be led for background information. And a similar objection was made by counsel representing Ms. Gopaul. The learned judge indicated that in his ruling that he will admit that evidence and give the appropriate warning to the jury insofar as it relates to that bit of the evidence. However, Your Honors, when Your Honors look at the summing up, there is absolutely no warning whatsoever insofar as it relates to the evidence given by the Nobrega in relation to the alleged commission of that other offense. And again, we're saying that is a fundamental error on which this honorable court can set aside that conviction as being unsafe, given the circumstances. So that I highlight that to show, Your Honors, the importance of giving the necessary warning in relation to the Nobrega. Because, and we have relied on the cases of Nur Mohammed and the Queen, and that's at page 702 of Your Honor's record of our authorities, and Arderton and the Queen, and that's at page 710 of Your Honor's record. To make
Sorry,
the
Mr.
point,
Gosai, I'm making a note
Carry on.
here. What is it you are saying the judge should have told the jury in relation to the evidence of the murder of the husband? What is the warning that the judge failed to give in relation to Gopaul?
Well, Your Honor, we're submitting respectfully that the judge ought to have warned the jury that you hear this evidence of the appellant Small and Gopaul, well, Gopaul in this case, conspiring to cause the death of her husband. But that does not mean whether it is true or not, that is evidence on which you can act to come to any determination in relation to the present matter.
I see.
So we're respectfully saying by leaving it hanging in the air, a jury can naturally come to that conclusion that the person, the appellant Gopaul, sorry, having quote unquote killed someone before, there's a likelihood that she committed the very offense for which she is now before the court. And that was the language used by the Privy Council in Nur Mohammed and in Arderton and the Queen.
Mr. Gosai.
Yes, please, Your Honor.
Apparently, Miss de Nobrega gave her statement to the police in the early phases of this investigation. So one would expect if that statement is made that there would be some investigation. I don't know if you know if that happened. I haven't seen anything brought in the trial. There was certainly no indictment on that point. Maybe you can't tell me, then I will ask the DPP when it is her turn. You would expect some serious investigation in an allegation like that.
Indeed, Your Honor, but as Your Honor rightly pointed out, I can't say whether any investigation was done in relation to that statement.
And that was, at least that was not clear from whatever happened during that trial.
That is correct, Your Honor.
Yes, okay, great.
Your Honor, I believe I have extended my submissions, the written submissions in my oral address insofar as it relates to the Nobrega. I don't believe that unless Your Honors have any questions in relation to that aspect of my submissions, I will move on to the other, which is the application by the Court of Appeal of the proviso. Because as I pointed out, Your Honors, the Court of Appeal did accept the arguments advanced by the appellant Gopaul in the Court of Appeal that the learned trial judge failed to give adequate warning to the jury in relation to both the prejudicial evidence and the overall evidence of the Nobrega.
Yes, go ahead.
Thank you, Your Honors. Now, in the Court of Appeal having agreed twice that the learned trial judge failed to give the jury the adequate directions, but nevertheless found that in all the circumstances of the case, that there was no substantial miscarriage of justice, given the errors that they would have highlighted, errors which the Court of Appeal accepted were made by the learned trial judge, including the error of failing to warn the jury on the two substantial pieces of evidence given by Nobrega against the appellant the appellant Gopaul. We are saying respectfully, and we have relied on Alexander and the Queen, Jennifer Swami and the state, Orilo Pop and the Queen, Nari Sukla and the state. And these are set out in our authorities that we filed with the court to make the point that the application of the proviso in this instance was manifestly unjust and unfair. And we accept, of course, that this honorable court would not lightly interfere with the exercise of a discretion by the Court of Appeal to apply the proviso. But we are saying that this honorable court can interfere in that discretion if it is not properly applied or applied in a manner which is manifestly unfair to the appellant before the court. And we are saying in this instance, given what I have highlighted in my written submissions as well as the oral arguments, that the application of the proviso in this instance in relation to small was manifestly unfair. And then your honors can go on to disagree that the Court of Appeal, agree that the Court of Appeal did not apply the proviso in a fair and just manner. Now, your honors, in relation to the sentencing, if your honors are to reach that stage in relation to the appellant Gopaul, that in the Court of Appeal, the submissions were made to the court setting out what Your Honor Justice Jamadar was asking of my learned friend, Mr. Daniels, in terms of comparisons of similar cases. So in the Court of Appeal, page 549 of Your Honor's record, that is the submissions made on behalf of the appellant Gopaul in the Court of Appeal. What I had done, Your Honor, was to set out the provisions of the Act, the sentencing that the Act is saying what is the eligible sentence in this particular circumstance, and then go on to cite cases from Guyana, from the Privy Council, from the wider Caribbean, to give a comparison of years applied for similar offenses of murder. And at paragraph 43 of my submissions, I had indicated or suggested or made the respectful submission to the Court of Appeal that a sentence of between 8 years and 30 years imprisonment would have been appropriate, given the number of cases I've cited, to show the comparison as to the number of years applied in the different jurisdictions. Now, in the Court of Appeal, in relation to the sentence, the Court of Appeal started off in the oral presentation in the Court of Appeal, Your Honor. The appellant would have indicated to the court that the manner in which Section 100, subsection 1 was set out in relation to the sentence that would be appropriate for the appellant Gopaul, that it was 15 years or life imprisonment. The other way around, life imprisonment or a term of years not exceeding 15 years. The point was made in the Court of Appeal that the starting point must be 15 or more than 15, but that it cannot exceed, we respectfully submitted there, what is deemed to be a life imprisonment term or a term of life imprisonment. So that the point we were making that if life imprisonment, for example, is considered 25 years or 30 years by other jurisdictions, there's nothing stopping our Court of Appeal from utilizing a number to say this is the term of life imprisonment. Then the sentence to be imposed must be 15 years or that number. Now, what the Court of Appeal did, the Court of Appeal started at 45 years, and we are saying fundamentally that is incorrect. We have given the examples used by the other jurisdictions in relation to the
Did they start
years.
at 45 or did they end up at 45?
Sorry, Your Honor, they end up at 40. They started at 30 and end up at 45.
Yeah.
They started at 35, Mr.
35, yes, please. Yes. Yeah. Thank you, Your Honor. 35 and ended up at 45. But we are saying, Your Honors, and we have developed that argument before Your Honors in our written submissions, that like this Honorable Court did in the case of Allen and the Queen, which is to do a historical overview of life imprisonment and other forms of sentences. And this Honorable Court made the point that, for example, in the Barbados position, a term of 25 years was deemed to be an appropriate number to be considered for life imprisonment. In Aguilera and the state, 30 years, I believe, was used to, quote unquote, define what a life imprisonment is. And we have made the submissions, and we're respectfully making it orally here, that this is an opportunity for this Honorable Court in the Guyana context to set a definition of what may be considered life imprisonment insofar as those sentences are referred to in legislation. And I say that because, Your Honors, when Your Honors look at the comparative cases relied on by the law and the DPP in terms of sentences imposed by the High Court and the Court of Appeal of Guyana, the numbers are jumping from, like, for example, in Gopaul's case, 90 years in the High Court to 30 years, the starting point of 90 in the High Court, starting point of 30 in the Court of Appeal. And the other cases that they've relied shows that it is all over the place. And we're respectfully saying that that is not keeping in line with proper administration of the criminal justice system. Because one is then left at the whims and fancy, if I may use those words respectfully, of either a court, a high court, or a court of appeal. And the numbers are just randomly plucked without any consideration or reason given as to how, for example, in the High Court, the law and the trial judge arrived at his starting point, and same with the Court of Appeal as to how the Court of Appeal arrived at the starting point. So we are saying, and I've suggested to this honorable court respectfully, that a period of imprisonment be between 8 and 15 years, of course, with the reductions. I have highlighted to Your Honors the submission that the time spent on remand and the time spent awaiting the hearing on determination of the appeal should be deducted from whatever sentence is imposed on the appellant Gopaul. And we rely on Brijlal Hariprasad, a decision given by Your Honors, 90 West Indian, for the point that the delay in the hearing of an appellant's appeal ought not to be used against that appellant. It is the state apparatus which is quote unquote failing or not efficient. The appeal was filed in October of 2015. It was heard and determined 6 years later in August of 2021. And we're saying that period of time that the appellant is waiting for an appeal to be heard and determined is unreasonable. And
what was the time of remand?
Sorry. Is it that the Court of Appeal's decision was that the sentence will begin to run from the date of the Court of Appeal's decision?
No, please, Your Honors. The sentence will run from the date of conviction.
From the date of conviction. And that
Yes.
date of conviction was some 5 years after they were first incarcerated, is that it?
Yes, please, Your Honor. They were convicted in March of 2015, and the appeal was heard and determined on the 31st of August, 2021.
No, but when were they arrested and when did their detention begin?
The Gopaul was arrested on the 3rd of October 2010, and her trial, the conviction was and decision was handed on the 15th of March 2015.
So the period that you're concerned with is the period between 2010 and 2015?
Yes, please, Your Honors. And also I'm saying that the court can also consider reducing from that time the time spent on awaiting the hearing and determination of the appeal.
Yeah, I don't know that part is relevant. If the Court of Appeal took the view that the sentence should run from 2015, how is it relevant the time she was awaiting trial in the Court of Appeal?
But we're saying respectfully, Your Honors, that the sentence imposed by the Court of Appeal should have started to run from 2021, the date of the decision of the Court of Appeal.
From 2021?
Yes, please, Your Honors.
That is what they said?
No. The Court of Appeal said that the sentence will run from the date of conviction. We are respectfully saying that if this honorable court was 2010, yes, please. 2015, yes, please. Yes, please, Your Honor. That is correct.
So that would already embrace the time that was spent waiting on the appeal, but not on the trial.
No, please, Your Honors. The appeal, what the Court of Appeal said that it will run from conviction, meaning it will start to run from 5th of March 2015, the sentence that the Court of Appeal imposed.
Yes.
But we were submitting then, we're submitting now, that the Court of Appeal should have indicated that the sentence should start to run from the determination of the appeal.
Why?
with the deduction. In other words, if they're sentenced to 20
you
years, it's
arguing
not
against the
20 from
question?
20. No, please, Your Honors. Maybe I'm not making myself clear. What I'm saying, Your Honors, is, and I've set it out in my written submissions, that if this court decide to get to the stage, if the court reaches the stage of sentencing, that the time spent on remand awaiting trial and the time spent incarcerated awaiting the appeal should be deducted from whatever is the final number
Okay,
that Your Honors are deciding to.
stop there.
Yes, please.
The Court of Appeal did not consider the time spent on remand,
That is correct.
but they clearly considered the time spent awaiting appeal. So why are you asking us, even astonishingly, to have the time, the sentence run from the date of the Court of Appeal's decision?
Oh, no, Your Honor. Maybe I'm not making myself clear. All I'm saying is that in addition to deducting the time spent on remand, we're also asking this honorable court to deduct whatever time. So, for example, if it's 10 years,
but they've
deduct
already
6
done
years.
that. If the Court of Appeal says the time would run from conviction, they have already factored the time that was spent awaiting appeal.
I understand what Your Honor is saying. Yes, indeed, because it will go back to 2010. So we're asking this honorable court
It'll
to
go back to 2015.
2010.
15.
Yes, please, Your Honor.
It'll go back to 2015, Mr. Gosai, the date of conviction.
Yes, please, Your Honors. But what I'm saying is the Court of Appeal did not deduct the
years.
Your
criticism is that the Court of Appeal did not deduct the 5 years on remand. Sorry, the 5 years it took to get to the initial conviction.
Yes, please, Your Honor. That is correct.
Right. Okay.
That's
Maybe
your
I wasn't.
criticism. That's your
That is
only
the
criticism.
Yes, please, Your Honors.
Right.
Okay.
In relation to that. So,
But so you're not saying, Mr. Kozai, because I want to be clear. Of course, the time that she spent waiting on the appeal and so forth, that has to be counted clearly. And you say even more, it has to go back to 2010. Understand that. You're not saying then that because it was such a long wait between the conviction and the appeal, that should trigger some extra discount, if I put it in those words. You're not saying that, correct?
That is correct, Your Honors. Your Honors, unless Your Honors have questions of me, that brings me to an end of my oral presentation.
I think yes, thank you very much. Madam DPP, or maybe we should take a 5-minute break. So, well, we'd hear you from 11, is now by my clock, 10:52. We'd hear you from 11 o'clock, Madam DPP.
Thank you, please, Your Honor.
Yes, Madam DPP, are you ready?
Yes, please, Your Honor.
Yes, please proceed.
May it please, Your Honors, we rely on our written submissions, which were filed with the court, and in particular in relation to the issues that were just discussed.
Can you adjust your camera? We're not seeing you.
Not seeing.
A little bit to your right. Yes, that's a lot better.
Thank you, please, Your Honor. May it please, Your Honors, we rely on the written submissions which we have filed. In addition, I will look at the submissions, the oral submissions referred to by my learned friends in there a while ago. First issue is the evidence against the first appellant, Mr. Small. In relation to Small, the admissible evidence before the trial court were the circumstantial evidence of the dumbbells which he had ordered to be made, as well as the dumbbells which he had ordered to be made, and those dumbbells were found tied to pieces of rope and attached to the suitcase wherein the deceased's body was found.
Those dumbbells were used for any other purpose?
He had a gym and he used the dumbbells.
So the fact that he had the dumbbells is probative of nothing, because they are not peculiar to a murder. They're really peculiar to a gym, and he owned a gym. Is that correct?
Yes, please, Your Honor, but he also had those dumbbells at the home of the number 2 appellant, and those dumbbells were found attached to the suitcase wherein the body of the deceased was found at the creek with her head bashed in. The child's head was bashed in.
Madam Director, I need particular help in relation to the dumbbells for this reason. The evidence and the presentation is that he owned the dumbbells.
Yes.
But the evidence is very clearly that those dumbbells were located at the home of Miss Gopaul and not at his gym. The evidence is therefore very clear that when the dumbbells were supposedly attached to the suitcase, they would have come from the home of Miss Gopaul and not from the possession of Small. And this is what gives me considerable difficulty in connecting Small, the dumbbells, and the murder. No, it connects the dumbbells having last been seen at Gopaul's home. It connects Gopaul and the suitcase and the murder. But they were not last seen in the possession of Small, and therefore, to my mind, there is not that nexus between Small, the dumbbell, and the murder, as distinct from the nexus that the dumbbell provides between Gopaul and the murder. Could you help me there?
Yes, please, Your Honors. Your Honors, I would like to refer you to the evidence of the witnesses Samru and Tiwari. Samru was the one who made the dumbbells or adjusted them, so to speak, on the instructions of the number 1 appellant. He welded them and he painted them black. And
Madam Director, I can help you. I totally accept that the dumbbells started off, if you'll forgive the expression, started off life as the property of Small. I totally accept that he is the one who gave them over to Gopaul. For all I know, he continued to own them while they were in Gopaul's possession. So that is not it. Tiwari and all the other persons who said that the dumbbells originated with Small do not put this matter that I'm inquiring about any further. What has me detained is the possession of the dumbbells, and it is very clear, it appears in the summing up as well, that the dumbbells had been located before the murder at the residence of Gopaul. So how can you connect that which was in Gopaul's possession with having come out of Small's possession to be attached to the suitcase?
May it please your honor, the evidence of Ashram Tiwari is that he saw Jarvis whip the dumbbells at Gopaul's home. And when he was and he saw Jarvis whip the dumbbells at Gopaul's home, he took the dumbbells to Gopaul's home for Jarvis. Jarvis used to be there living at Gopaul's house and using the dumbbells. Further, you have the evidence of the witness, Samru, who said that the dumbbells were so heavy that he could not handle them alone. And this supports the evidence of Tiwari that it was Jarvis who was using the dumbbells at Gopaul's house.
Where were the dumbbells located, Madam Director?
On a suitcase attached to the DC.
No, they were located at Gopaul's house. Page 469 of the summing up makes very clear that that is where the dumbbells were located.
And also, too, that is where Jarvis used to be. He used to be staying home at her temporarily, and he was using the dumbbells at that time.
That's perfectly fine, madam. But when the dumbbells were attached to the suitcase, presumably from all we know, they were attached from having been at the location of Gopaul's home and not from in the possession of Small. That is what troubles me.
Just a minute, madam. Just a minute. I'm not seeing Justice Jamadar.
President,
Registrar, yes, can you see if you can get on the phone?
Yes, I just spoke with him. I think his internet has knocked him off. He is trying to get back in, so I may respectfully suggest that you stand the matter down for a few minutes. And we'll try to call him to see what's happening, because he can't listen in on his phone as we speak. But I just spoke with him, and he's trying as much as possible to get back on, but he's having some problems.
So I'm sorry, Madam DPP, we'll have to take a short break and just stand by. And when you see the judges appear, then you know that we are ready to resume. So we take a short break.
Thank you, Mr. President.
a connection to Small outside of the fact that he owned those dumbbells?
Maintains, Your Honor, it's just not merely that he owned them, but that he used them. He was the person using the dumbbells at Gopaul's house. It was only there for a matter of convenience for his use. And we see that from the evidence of Tiwari, where Tiwari said, and that is at page 414 of the record, he said, I went to the home in September 2010. Barry was back and forth between the two houses. We used to meet almost every day, me and Barry. I took Barry to Nari before when his vehicle was not working. I don't agree that I can't say dumbbells belong to Jarvis Small. There's no evidence. The prosecution's case is that the dumbbells belonged to Small, and it was taken to Gopaul's house by Small for the use by Small of the dumbbells.
And where is that evidence?
In the evidence of the witness, Tiwari. And Tiwari's evidence is more particularly at page and the evidence that I'm referring to is cross-examination evidence at page 413 and 414 of the record, please, Your Honors. So, may it please, Your Honors, there's no evidence in the prosecution in the case here that Gopaul ever used the dumbbells. The evidence of the witness Samaru is that he had made the dumbbells, he had adjusted them on the instructions of Small. They were very heavy. They were so heavy that he could not handle them alone. Our respectful submission is that.
Just a minute. There is evidence that Small used the dumbbells at Gopaul's home. Where is that evidence?
In the evidence of Tiwari. And then at page 414, he says, I went to that home in September 2010. Barry was back and forth between the two houses.
Yes.
Used to meet almost every day. I took Barry to Nari before when his vehicle was not working. And then he said at the top of the page, I never handled any weights at Nori's house. Sometimes when they are fixing the motorcycles, I would hang around. I did see distinguishing marks on the weights at Nori's house. I saw the same weights at the Rumville police station. I agree that the second plate has a brake. I never saw any brake on any plate in Nori's house. I said Rusty.
But Ms. Ali, what you said to us, are you misleading us? You said to us that there was evidence that Small was using those dumbbells at Gopaul's house. And I want to see where that evidence is on the record.
I went to that home in September 2010. Barry was back and forth between the two houses. We used to meet almost every day.
Wait, are you saying that we used to meet, what they used to meet to exercise? Is that an inference that can be drawn from evidence that came before? How they used to meet every day? Is that where you're trying to peg it?
In addition to that, please, Your Honor, let's go to page 410. This is the examination in chief. I saw motorcycle parts, weights, and some other parts belonging to his tin shop that he had there at Nari. I saw 2 sets of weights, a pair of dumbbells and a barbell. Barry told me he had them there so he didn't constantly have to go back and forth from his wife's house and Nori's house. So this is the evidence of Tiwari that Barry had a set of weights at Nori's house, which he was using so that he won't have, and he had another set at his wife's house. So he had a set at each house and he was at the 2 houses. The dumbbells were locally made. They had different sizes of plates and they were rough around the edges. I would take Rocky to Nori house to conduct motorcycle transactions. Barry would normally buy motorcycles and Rocky would repair them. We went to Nori's house a few times. I saw motorcycle parts, weights, and some other parts pertaining to his tin shop that he had there, Barry had there at Nori. I saw 2 sets of weights, a pair of dumbbells, and a barbell. Barry told me he had them there so he didn't constantly have to go back and forth from his wife's house and Nori's house.
That's a 410 DPP. That's the evidence in chief at 410.
410, please, Your Honor.
But I still didn't hear that he was using them, but that might be an inference.
It's an inference, please, Your Honor.
But okay, so he was using them for the inference would be then that he was using them for weightlifting or training or whatever. And then the question is, so what? Because he was using that there in that house, but he wasn't constantly there. The weights, the dumbbells were in that house. So there is a connection between the house of Gopaul and the suitcase within it, her daughter, but other stuff too, which came from the house of Gopaul. So that seems to be a clear connection. But where does Mr. Small come in?
Please, Your Honor, the weights are very heavy, and it's our case. It was the prosecution's case that the weights were so heavy that it was Barry Small who had to have been handling them. And he would have handled them in placing them on the suit.
Madam DPP, so I could understand the inference, so she needed a strong man to help her. But where is the proof that that strong man is small? Might be probable, might be likely, but we're talking about beyond a reasonable doubt.
And you see, this is why the evidence, the decision not to have split trials was extremely unfortunate, because let me ask you the question, Ms. Ali. Was there any form of direction that could have been given in relation to the Nobriga's evidence that could disabuse a lay jury of the notion that Small should not be prejudiced by that evidence?
Yes, please, Your Honor. There are directions that could have been given, and a direction was given.
That direction was sufficient to have the jury not take into account. There's nothing that the Nobriga said that is relevant to Small's guilt. You agree on that?
Yes, please, Your Honor.
If there were split trials, the Nobriga would not have been a witness because her evidence is irrelevant.
Yes, please, Your Honor.
So, how was it humanly possible? You opposed the split trial?
Yes, please.
You opposed that?
No, please. I thought you supposed. Opposed. Sorry.
Okay. Did you agree with a joint trial?
Yes, please.
On what ground?
Because it was one transaction, it was one murder, and the prosecution's case is that it was committed by both parties. And the evidence against the accused Small, the appellant Small, is that he had the dumbbells. The dumbbells were heavy. He was the person who lifted them. He was the person who took them to Gopaul's house. And after Gopaul's house, these dumbbells were found attached to the suitcase wherein the deceased's body was found. And when we look at the deceased, the type of murder, the harrowing, the brutal murder where her head was bashed in, that also has to be done by someone who is strong. I know my friend. I know that's
question. Ms. Ali, you're not answering my question. How does a split trial affect all of what you're saying? Couldn't you at the split trial give all of that evidence as well?
Your Honor, it's one criminal transaction. It's a joint, it's a murder, and would have been the same except for that witness. All the other witnesses would have been the same.
No. Let me ask the question this way. Could you have gotten conviction in this case of Gopaul without the evidence of the Nobriga?
There was circumstantial evidence, please, Your Honor.
Could you have gotten a conviction of Gopaul without the evidence of the Nobriga?
Yes, please, Your Honor. There was circumstantial evidence. When we look at the circumstances, the body is found in the suitcase. Suitcase was from Gopaul's home. The rope was at Gopaul's home. The passbook, the bank book, and the passport were in the suitcase, and those were documents that would be in the possession of the mother, and those were all in the suitcase in which the deceased was found.
So, and all of those things, leaving out the Nobriga's evidence, linked Gopaul to the murder?
Yes, please, Your Honor. Your Honor, it's circumstantial evidence.
Just now, step by step. But did those things link Small to the murder?
There is also evidence, circumstantial evidence, linking Small to the murder. We have the dumbbells, which he purchased, and we have the evidence from Samaru that he brought them to him. He bought them from him. He asked him to do the modifications. He painted them black, and then you have the evidence of Tiwari that he saw the bells at the house there, at Gopaul's house, that Small was using. Small was using the dumbbells.
So you don't think that Small would have occasioned significant prejudice from the jury hearing what Gopaul allegedly said to the Nobriga?
What the evidence that the Nobriga gave would have been cured by the directions of the trial judge to the jury. The trial judge did direct the jury that the evidence of one accused is not the evidence against the other. And that is in the record.
And you think that that was a sufficient direction, what the trial judge said there?
Your Honor, it could have been more detailed, and as at page 137, line 25, in the summing up, the Lawrence trial judge says, if you believe what she said, it is not evidence against Jarvis Small. It is a simple rule. The evidence of one accused or the statement of one accused is not evidence against another accused.
Madam DPP, the criticism, I think, is this. Even if we reach that stage, given the highly prejudicial nature of the evidence, the trial judge should have at least said, when the Nobrega said ABC about Small, disregard that. That is not evidence in this case against Small. When the Nobrega said DEF, etc., etc. In other words, seriatim, particularize identify and particularize every single potentially prejudicial statement and specifically disavow it. That was clearly not done. What was done was a very general, generic, almost legalistic direction about accused and co-accused. So I think...
Madam Director, in relation to the question the President asked you a bit earlier about if more could have been done to, as it were, minimize the prejudice of this inadmissible evidence in relation to Small, I want to, for the purposes of this case, and I will rely on it for the purposes of this case, and I want to draw your attention to it for future trials. There are two cases which I would want to draw to your attention. One is Midis, which was cited by Counsel for Small, so that is in the record. It is, we don't need to bother about the citation. The short of it is, there is a statement at page 6 of that judgment, which says that when a judge is directing the jury, he should direct the jury separately in the summing up in relation to the evidence admissible against each accused. What the judge did in this case was to narrate the evidence of each witness in relation to both accused. So the judge said the evidence against, in this case, is as follows, and he narrated, he summarized. So the evidence in this case includes the evidence of the Nobrega. What the judge ought to have done according to this suggestion was to have said, no, I will summarize the evidence for you, and I will summarize the evidence generally. And then when it comes to dealing with the evidence of the Nobrega, he should have said to them then, I will now summarize the evidence of the Nobrega. Before I do, let me tell you that this evidence is not to be considered in relation to the case against Small. That is what the judge should have done. The other case is cited in the Midis, and that is R against Towle, T-O-W-L-E. The citation is 1954, 72 WN 338 at 340. I'm not suggesting that you should look it up now at all. I'm just drawing for reference point your attention to this. And what is suggested in Towle is that at the point when this inadmissible evidence is about to be called, the judge should then, before the evidence is given, give a direction to the jury. This witness will testify. I want you, when you listen to the testimony, to appreciate before she begins to testify that this is not evidence against the witness Small. And therefore, when you are considering later the case in relation to Small, do not consider this evidence. And that, I suggest to you, Madam Director, in response to the President's question, is the sort of thing which may have gone in a case where there was a joint trial and there may have been prejudice, not to my mind exceptional prejudice like this, but where there may have been prejudice, that is the sort of direction which should be given. Obviously, in this extreme case, nothing of the sort was done, and I therefore suggest to you that it is a particularly egregious instance of the separation of the inadmissible evidence as against Small not having taken place. Thank you.
May I please, Your Honors, I beg to differ and I refer Your Honors to page 110 of the record. Members of the jury, and I start at the beginning of page 110 or 137. I'm seeing two different numbers. And it's 137. It states, members of the jury, there are certain things that I would like to tell you that you have to bear in mind when considering the evidence of the Nobrigo. Firstly, and this is at the beginning of the Nobrigo's evidence, judge has not yet begun to direct the jury on the Nobrigo's evidence. And he says, members of the jury, there are certain, which is exactly what Your Honor has just said. There are certain things that I would have to tell you that you have to bear in mind when considering the evidence of the Nobrigo. Firstly, at the time this witness told the police the story was told to her, she was not a convicted prisoner. She was there awaiting trial on charges. It is not unknown for a person in such a position to place themselves in favor with the police and to give the police information that an accused with them in the same cell had admitted to, and or which they are presently held and hope to get an advantage by doing so with the police. Learned trial judge goes on, members of the jury, when considering the evidence of the Nobrigo, you will be needful when considering the witness evidence. You first have to consider whether you believe Bibi Gopaul did tell the Nobrigo the story before you accept it. And if you accept that she did tell her the story, you then have to determine whether you feel sure that the contents of the story is true before you can act on it.
Madam Director, if I may interrupt you.
Please let me finish, because I'm coming to the other part. Members of the jury, remember, as I told you before, unless you decide that an accused, any one of them, made a particular remark or statement, you cannot consider it in deciding the case. After such determination, I will remind you also that with respect to Jarvis Small, nothing that you accept Bibi Gopaul to have said is evidence against him. Let me explain. There are several things that it is alleged that Bibi Gopaul said to the police and to the Nobrigo. You will first consider whether you believe that she said these things. If you do believe that she said these things, you will then consider whether you believe what she said to be truth. Then you act on it. If you believe what she said, it is not evidence against Jarvis Small. It is simple rule. The evidence of one accused or the statement of one accused is not evidence against another accused. And then, please, Your Honors, then he goes on to give the evidence of the Nobrega. May it please, Your Honors, the trial judge did direct the jury. He did convey the meaning that he did convey the warning that they were not to act on the evidence of the Nobrega against, it was not evidence against the Small, and that direction was clear to them. There could have been more detail, and this is what the Court of Appeal did allude to, and that was their reason for applying the proviso. But it's my respectful submission that despite that, there was no miscarriage of justice, because when one looks at the evidence as a whole, there was nevertheless sufficient evidence, and this is the issue, well, there was sufficient evidence upon which a jury properly directed might have convicted, and they did convict, please, Your Honors.
You see, that's exactly what
I speak now, Director.
Yes, please, Your Honor. Sorry.
That's all right. You are missing the substance of the point, you know. There is no doubt that the judge told them in the course of the summing up in relation to the evidence as regards both accused, that when you consider the Nobrega's evidence, that is not evidence against Small. But this is in the process of summing up the evidence against both accused together. So what he did is he summed up the evidence of the Nobrega and warned the things which you will hear, some of it should not be used against Small. The proposition in the cases I cited was that there should be no need for that, because the things recited from the Nobrega's testimony should be stated in relation only to the judge saying, I will sum up the evidence in relation to Gopaul. So that when the judge comes now to say, I will sum up the evidence in relation to Small, there is simply no reference to the Nobrega's testimony. There is no need to say that you need to consider whether you believe that Gopaul told the Nobrega the things which the Nobrega said were stated, etc. It is that there should be two separate strands of summing up the evidence against Gopaul and the evidence against Small. So that is the point. Read the cases.
Maybe, if I may, Madam Director, if you look at page 151, there you see that even the trial judge seems to have blurred some stuff. He's saying there at 15, the state is saying that the magnitude of the injury shown shows that death was intended. The state is saying to you that those injuries, based on what Dr. Singh said, had to be inflicted by Jarvis Small because of the force required, as Dr. Singh referred to. And then he says, and the evidence of the Nobrega proves nothing against Jarvis Small, but proves against Bibi Gopaul that she was acting in concert. So he's saying one thing, mentioning Jarvis Small, that would flow from, and then he's saying, but you cannot use it. And then continues, again, in this regard, and in this element, you will consider the injuries as for the testimony of Dr. Nihal Singh. If you are satisfied so that you feel sure that the injuries were inflicted upon the deceased by an accused with the intention of causing death or serious bodily harm, you are entitled to find that the required intention of the crime has been proven. But you will have to further determine whether you find he inflicted the injury and she was acting in consort, etc. So you get this impression that the judge is saying you cannot use it, but then he uses the name Jarvis, he uses he inflicted the injury, etc. It's for lay persons, if I may say so, very difficult to distinguish, seems to me.
Yeah, I have not seen a clearer case that cried out for separate trials, quite frankly, because when it is said upon the whole of the evidence, well, if you're looking at it from small standpoint, what is the whole of the evidence? When you're looking at it from small standpoint, the whole of the evidence cannot include anything that the Nobriga said. And so from that standpoint, it is impossible for me to see how one can apply the proviso, because the whole of the evidence means nothing in relation to small. You have to exclude all of that evidence from the Nobriga, which is so potent, so complete against Gopaul, if you believe the Nobriga, but which has no bearing whatsoever on small. It is impossible for any human being to separate out what the Nobriga says small or Gopaul told her that small did from what is probative against small. It's difficult enough for a professional judge to do so, much less a lay jury.
But even apart from that perspective, let's look at the no case submission, because that comes back to, apart from the fairness of everything, what evidence do you have against small? And only thing I have heard, Madam DPP, is we had a dead body in a suitcase, and there were dumbbells keeping that suitcase down in the water. The dumbbells were his dumbbells, and you mentioned all kind of witnesses who confirmed that. So let's assume that that is so. These were his dumbbells, but they were in the house of Gopaul, like other stuff that was found in the suitcase. We can assume that maybe these things were so heavy that she must have had help from somebody, and you could think most probably small, but most probably is not enough. Must be beyond a reasonable doubt. Where is the other evidence? This is what puzzles me. I don't see it. It's a terrible case, and it would be best to do justice. But the point is, to do justice must be based on solid evidence.
See, the criminal justice system has rules. They have rules. And when we start bending the rules, we find ourselves on a slippery slope. Sometimes the rules may not work out the way that we think they should work out. But anytime we start bending those rules, we are on a very slippery slope, a very, very slippery slope. Yes, Madam DPP, go ahead.
Please, Your Honor, the evidence that Your Honor just referred to, that's circumstantial evidence. And that's how a circumstantial case is proved. You have to look at all the circumstances and look at them together. You look at the circumstances of the dumbbells. They belonged to Small. He used them. He was strong. He was seen using them. It was found at the scene of the murder. The type of injuries the deceased have, they had to have been inflicted by someone who was strong, and it is a prosecution's case. And when we look at all the circumstances, The one conclusion that we can come to.
What were all the circumstances? This is the point. You are using the prejudice of the Nobriga's evidence against Small. What are all the circumstances?
No, please, Your Honor, we're not using the Nobriga's evidence. We are using the circumstantial evidence, and we're looking at all of the circumstantial evidence.
Well, you tell me, what are the circumstances? You talked about the dumbbells, yes? What else?
The weight of the dumbbells. Those dumbbells were so heavy they had to have been lifted by someone who was strong.
Mr. Jarvis, Small is the only strong man there is in Guyana?
No, but he was using those dumbbells. He was in contact with the deceased. There was a report made against him by the deceased. So there's a motive. You're seeing a motive there. And then the deceased is found with those same dumbbells in a suitcase with those same dumbbells attached. It's a strong circumstantial case. And as Archibald says, a circumstantial case is circumstantial evidence is the best evidence. Because sometimes we can have eyewitnesses who give oral testimony and they can be lying witnesses, and they can be a lying witness that is a convincing witness. But the circumstances are strong, please, Your Honors. And it had to have been someone who was strong enough to lift those dumbbells, which we respectfully submit Small was doing, that also used that same type of force to bash in the deceased's head.
Is there forensic evidence that those dumbbells were used to bash in the deceased's head?
No, but the head was bashed in. The evidence, the post-mortem examination report said the head was bashed in.
So we don't know whether the head was bashed in by a dumbbell or by a hammer or by anything else.
No, we're not saying that it was bashed in by the dumbbells, but we're saying that it was someone strong enough. Your Honor,
because force was used against the deceased, it means that Jarvis inflicted that force?
Given all the circumstances, that's what the prosecution's case is. Because of the strength in him using the dumbbells and his dumbbells being found on the suitcase wherein the body was found. So there's a separate circumstantial case against Jarvis, and there's a separate circumstantial case against Gopaul. You have two accused persons with circumstantial evidence. And in addition to that, you have the evidence of the cellmate, the Nobriga, that goes towards Gopaul's case.
Tell us about the sentence.
May I please, Your Honor, the Court of Appeal, and I wanted to bring to the court's attention what where the appellant's submissions ended in relation to the sentence, and it was submitted by the appellant's counsel that there was the 5 years spent on remand awaiting trial was not considered by the Court of Appeal. But I'd like to bring your Honor's attention to page 24 and 25 of the judgment, the decision of the Court of Appeal. And we start at page 24. We consider at line 13. We consider also whether this is, in this regard, whether this is a fit case for the application of the proviso. Not this part, sorry, please, Your Honor. We have considered whether there would have been any substantial miscarriage of justice. No, we continue. Now we turn to the issue of sentencing, line 23. The complaint here is...
What page? The CCJ page?
Page 24. I have page 24 of 28.
I see. Okay.
Line 23. Now we turn to the issue of sentencing. The complaint here is that the trial judge erred in the sentence imposed, and that the sentence was excessive. The trial judge did not give, and there's some notes, an analysis or breakdown into the sentence. No evidence was led in court in relation to aspects of which the trial judge would have taken into account in coming to his sentence. It was also complained that the trial judge did not disclose mitigating factor when handing down his sentence, and neither did the trial judge hold a sentencing hearing, as was advocated for by the Caribbean Court of Justice in the case of Linton Pompey and the state. So the first point I wanted to make here is that the Court of Appeal did refer to Linton Pompey's case, which was the only case available, because Calvin Ramcharan's decision was only given this year, and this hearing in the Court of Appeal was in 2021. So Calvin Ramcharan's decision of the CCJ would not have been available to the Guyana Court of Appeal at the time when the decision was given. But Linton Pompey was available, and the Court of Appeal of Guyana did use the Linton Pompey's case. The state has accepted the submissions of the defense, and I go down further, and let's go to the next page. Line 3. This is on page 26, please, Your Honors. Doing the best we can in the circumstances of this case, rather than sending this case back for consideration of the sentence, we are considering the factors as enumerated in Aguilera and the state, Tirat and the state, and 2 recent decisions from this court. It has to be court. One given yesterday, one given last month. Applying those factors relevant to the offense, we believe that the starting point of 35 years is appropriate for the following reasons. And the reasons are listed: the age of the deceased, as we said, a child. The offense was committed by persons who are close to the child. You have a position of trust there, Your Honors. The violence used, as mentioned by Dr. Nihal Singh in his post-mortem report, and his Vivivoki evidence, amount of violence used. See, Dr. Singh did testify, and he stated the amount of violence that was used to cause death, which is blunt trauma to the head. The method of disposal of the body of this child. The fact too that this child was known to or was related to the appellant. This offense was committed by none other than the mother of the deceased child.
Yes, we see the list of matters there. And what is your conclusion as to the sentence?
And then the Court of Appeal went on to state, the time spent, let us just have one moment to Court is of the view that no deduction should be granted for the 5 years spent in pre-trial custody for the reasons given in relation to the aggravating factors as outlined earlier in this judgment. Next, Mr. Please, John.
Yes.
I just wanted to refer to the case of Linton Pompey. And in the case of Linton Pompey, you have a page, at paragraph 152. What should be the starting point? And B, the period of time. And it states here, at paragraph 153, how then should a court determine the appropriate starting point for this particular sex offense? In Solomon Helm, the U.S. Supreme Court indicated that determinations of this nature required a proportionality analysis that should be guided by objective criteria, such as 1, the gravity of the offense and the harshness or severity of the penalty. My respectful submission is that the Court of Appeal would have done this in sentencing. They would have looked at the gravity of the offense and the harshness or severity of the penalty. The sentences imposed on other criminals in the same jurisdiction, and I did state the statistics for Guyana and what are the sentences being given by the Court of Appeal for the offense of murder. The sentences imposed on other criminals in the same jurisdiction, that is whether more serious crimes are subject to the same penalty or to less serious penalties. And 3, the sentences imposed for commission of the same crime in other jurisdictions. The court is of the view that courts are competent to judge the gravity of the offenses, at least on a relative scale. Comparisons can be made, the court stated, in light of the harm caused or threatened to the victim or to society and the culpability of the offender. The honors, this was a very serious case, and it concerned a mother betraying her trust with her lover and killing her daughter, and the daughter suffered a gruesome murder. I respectfully ask this court to look at the seriousness of the offense. And I refer to paragraph 45 in Pompey's case. Children are vulnerable, they need to be protected. Children are developing, they need to be nurtured. Children are precious, they must be valued. Society has these responsibilities both at the private individual levels and as a state. And then it goes on that, well, this was in relation to sexual offenses, but I feel it is also applicable to this offense. Sexual offenses against children, of which rape may be one of the most vicious, and rape by a person in a relationship of trust in the sanctity of the family home, the most damaging, is anathema to the fabric of society. The idea of it is morally repugnant. And this can be applied here in this case, in that this child was in the sanctity of the people in her home she was attacked by. That's the prosecution's case, her mother and her mother's lover. And not simply the mother's lover, but the mother's lover who had made sexual advances towards her and whom she had made a report against to the police. It goes on, and this is Pompey. At paragraph 46, the Universal Declaration of Human Rights asserts as its first principle that all human beings are born free and equal in dignity and rights. Children, minors, and all vulnerable young persons are owed a special duty of protection and care by both the society at large and the justice system. And then paragraph 87, the objectives of the public interest and public trust and confidence, and the preservation of the rule of law when I consider the human rights aspect in this matter. And then paragraph 127, and referring to Lashley and Campaign, which is another decision from this honorable court. We are deeply conscious that speaking generally, an appellate court, and certainly a final court of appeal, should be slow to interfere with a sentence imposed by a lower court. I respectfully ask this court to be slow to interfere with the sentence granted by the Court of Appeal. Court of Appeal started with a starting point based on Pompey's case of 35 years, given the circumstances of the case. And every case shall be judged on its own circumstances. Sentencing is contextual.
Okay, I hear all of that, Ms. Ali. Do you have anything to say about the failure of the Court of Appeal to properly apply Romeo da Costa Hall, which is a decision that bound them?
Maybe it's your honor that if you have reasons, you don't have to apply and there were no mitigating circumstances in this case, and the aggravating circumstances were very strong. And what was important is for the Court of Appeal to have known that they should do that, to acknowledge it, and then to decide and to state whether they did it or they did not do it. And they stated
Is it your understanding that the principle in Romeo da Costa Hall is that time spent on remand is not an aggravating, is not a mitigating, it is not to be treated like that. It is simply to be set off against the sentence or to be fully factored in the giving of the sentence. Is that your understanding of that case?
there has to be reasons, please, Your Honor.
The what?
There has to be reasons. And when you get the reasons, and the reasons will go towards the mitigating or the aggravating circumstances.
Your understanding is that the Costa Hall says that courts have a discretion as to whether to set off time served on remand against the sentence. That's your understanding of the case?
Yes, please, Your Honor. It is a part of the discretion of the court to sentence. Discretion of the court to sentence is strictly in the discretion of the court. And even this honorable court said that in Lashley campaign, you will not interfere with the sentence given by the trial court. Once they did, it is not excessive and it did not apply the wrong principles. And there's no evidence that we have that the Court of Appeal granted an excessive sentence or...
Ali, you take me on a kind of a tangent. There is in the Costa Hall a discrete principle that is set out there. Namely, that when you send a person to prison, you must factor in full the time spent on remand and set it off against the sentence. Isn't that your understanding of the case?
It may be, and that's
that
what...
may be your understanding, or it may be set off?
It may be set off.
I see, so that there are some circumstances where you simply don't feel like setting it off and you don't set it off?
No, you can't do that. You have to have reasons. And the reasons have to be grounded in the facts of the case. Every case is different, and every case has to be decided upon the facts of the case. And this was a gruesome murder by the mother and her lover of a child.
We know all of that. There's a very gruesome murder, position of trust. This is a heinous crime by any standards. I am not dealing with that. I'm dealing with the principle of time served on remand, and whether it is your view that you can simply take it into account on some occasions, or if on some occasions you find it's a very gruesome murder, you simply don't take it into account. Is that your understanding?
Yes, please, Your Honor, in the rare of the rarest cases, and this is the rare of the rarest cases, in the worst of the worst cases.
Yes. Mrs. Ali, can I ask one question, please? Is it as well, not just your view, but the view of the judiciary of Guyana, that this is a matter of discretion, and in an appropriate case, one can give you don't have to count the years spent in pretrial detention? Is that generally what is thought of in Guyana?
Yes, depending on the circumstances of the case.
Well, that's our fault. We clearly have not made ourselves very explicit on that issue.
I personally think it's very clear, but we shall give that clarity once more.
Yes, is there anything else you have to say to us, Ms. Ali? So in your view, the two convicted persons, their appeals should be dismissed and their sentences upheld. That's your view?
Yes, please, Your Honors. And I look at the best interest of the child, and ask this court as the parents patrie to not interfere with the sentence of the Court of Appeal, because it was just given the heinous nature of the commission of this offense by no less of a person than the mother of a child and her lover, and a lover who attempted to abuse that child too. And this is a heinous case, and the society looks towards the court to give a sentence that.
Miss Ali, you are a minister of justice. You are the director of public prosecutions in Guyana, so that your statements have to be very measured and careful. How can you be saying that that small sexually assaulted the deceased? He was convicted of that. There was an allegation and then it was withdrawn, and then there was another allegation and it was withdrawn again.
No, please, Your Honor, it wasn't withdrawn the second time.
But even so, it's an allegation. It hasn't been an allegation that has been tested, so you can't make definitive statements about something like that. You could have a suspicion, but a suspicion is one thing. To make a definitive statement and to urge a court to act on the basis of that definitive statement, you can't do that.
Madam DPP, I have, if I may, another question. We're talking about the protection of children. And of course, that is very important, but I didn't get the impression that the police has protected this girl very much. As you said, there was a second allegation. A police officer sees Small in a car. They don't do anything to arrest him. If it is true that that is what you think, that he is responsible for this thing, it wouldn't have happened if he was arrested. Don't you think that that is a wrong policy, and shouldn't that not change?
Your Honor, I have recognized what happened in this case, and the police were slow in acting,
right,
and leaves much to be desired.
Okay, so we hope that attitude will change. And one other point, if I may, of course, Ms. de Nombrega was talking about the murder of Gopaul's husband and so on. My simple question is, was there any attempt to investigate that? We don't see it in the record, but was there any attempt to investigate that point?
Your Honor, when that was brought to our attention, the body would have already been buried, and you would have needed the cause of death there.
And so you didn't further investigate that?
No.
Thank you.
Yeah, but you see, that's the thing. Let's just put it this way, that it's unfortunate that there was not any serious forensic evidence in this case to help to provide proof of who committed this murder. That is very unfortunate. And rather than conjecture and suspicion and probabilities, criminal law depends on proof, and proof requires proper investigation and the use of the tools that will yield good evidence. This is a very, very serious crime, but there you go. Yes, is there anything else you wish to tell us, Ms. Adi?
Your Honor, I just asked that whatever decision the court makes, that it communicates society's condemnation of the of the gruesome murder of this child by someone no less than her own mother and the lover of her mother. And
Madam DPP, please do not for a moment, in spite of what you may have experienced as a little bit of a brisk interrogation, please do not for a moment think that any member of this court is not acutely aware and grieved by the heinousness of what occurred. We all are, we understand the pain and trauma, not just to victims and to family, but to the entire society. Our roles as ministers of justice is to try and do justice according to the law and to keep at the forefront of our minds the presumption of innocence and the burden and standards of proof. And as the president said, the other rules that guide the justice system. The justice system does not pretend to be perfect. It aspires to do truth and justice, but it does so in the context of rules. But I just want, on behalf of the entire panel, to assure you, and insofar as Mr. Hughes and Mr. Gosami and Mr. Daniels advocates together with yourself in this matter, that this court is extremely grieved by what has transpired. By any measure, it is reprehensible. So do not for a moment think that that is not our clear view on the event, but that is not what the business of this hearing is entirely about. Thank you, President.
Yes, thank you. Thank you very much, Ms. Ali. Mr. Hughes, do you have anything further to say?
No, Your Honor. Thank you very much. I do not.
Mr. Gosai?
Thank you, Mr. President. Your Honor, just in response to a question posed by Her Honor Justice Rajnath Lee in relation to how the judiciary treats with the Costa Hall decision. There is a decision from our Court of Appeal, Nero and the state. I refer to it in our submissions. It's at page 1003 of the appellant's authorities before your Honorable Court. In that case, the Court of Appeal said, as a general rule, full credit should be given for time spent on remand in terms of years or months. If the judge was not of the view, given the circumstances, that little or no reduction should be given, clear reasons should be given. The Costa and Hall applied. So that was just to highlight to the court that seemed to be the manner in which the Court of Appeal of our jurisdiction is interpreting the principle in the Costa Hall. Thank you, Your Honors.
Yes, thank you. Thank you very much. Well, thank you, Counsel and Madam DPP. We will take time for consideration and we would let you know when we are ready with our decision. Madam Deputy Registrar, you may close the proceedings.
Thank you, President Saunders. Thank you, Mr. Justice Witt. Thank you, Madam Justice Rajnath Lee. Thank you, Mr. Justice Barrow. And thank you, Mr. Justice Jamada. Thank you, Counsel. And thank you to the staff of the Caribbean Court of Justice. This court now stands adjourned. Good day to all. Thank you.
Good day.